This is an examination of the hidden human condition.
This is the Hidden Killers Podcast.
The Hidden Killers Podcast.
With Tony Bruschi.
Interesting guest this afternoon, one of the nation's leading criminal defense attorneys, joining us to talk about the Kohberger case. Alexandra Kazarian of Garagos and Garagos. We are going to dive into the world of everything that's been going on and just kind of get a 10,000-foot overview of where she thinks this case is at, where it's heading, what are the potential pitfalls, advances for it. Let me just start here. Obviously, the public opinion is pretty damning. The evidence that we're seeing on the outside doesn't look all that good. Is this something where the public needs the boogeyman and he seems to fit it pretty well and we're just going to damn him very swiftly because he's there? Or does he have, much to stand on? And it's just the public is very quick to say, yes, you must be the man.
Well, I think it's a lot of both. I think that there is some evidence, circumstantial evidence, obviously, that ties him to the scene of the crime. We've got some reports that a car that was registered to him was at the scene. We've got these Instagram accounts that, do need to be verified, but seem to be tied to a phone number that he used that were following the girls. So there is suspicion that he had marked these girls and that he perhaps had tried to get in touch with them, and that may have been a motivation. There's obviously the circumstantial evidence of his studies and the study that he put online, asking very, very specific questions of people who got away with crimes, how they got away with it, how they felt about getting away with it. But again, this is all circumstantial evidence. And one of the things that people need to know about circumstantial evidence, you hear that statement, you hear that phrase thrown out all the time. But what people don't understand about circumstantial evidence is if it's not direct evidence, if it's not, I saw him stab her, if it's because I saw the car outside and think that he may have known them, if it's a group of facts that point to guilt, if there is a reasonable alternative scenario that points to innocence, a jury will be told that they must choose the scenario that points to innocence. So you've got the fact that he is trying to get a doctorate, like a super villain in a Marvel movie.
Sure.
He's trying to be a doctor of criminal behavior, basically. Is that evidence that points to the fact that he commits crimes or that he committed this crime in particular? Well, it's circumstantial evidence, but is it also evidence that he's just, a doctorate student and that he, for not nefarious reasons, he's studying, a valid a point of study? So yeah. Can that evidence that he is getting a doctorate be evidence that he is inclined to commit this crime and did commit this crime? Sure. But if there's a reasonable alternative scenario that it is a accredited, certified course of study that non-criminals are taking, then you cannot use it towards that. So that's the issue with the evidence itself. Now, it's a fascinating case.
Yeah.
People were gripped by the fact that there were 4 clean-cut college students who seemed to enjoy their life. They were like characters on a sitcom. They all loved each other. They hung out together. And all of a sudden, they were brutally murdered with 2 other roommates. How could they have not seen anything? How could they have not heard anything? So it was a absolutely fascinating case. So yes, absolutely. I'm sorry about that. The public has been gripped, and the public definitely wants to vilify somebody who may have had anything to do with it. I think it's bold.
Once we dive into things like this, I mean, it's very difficult for the public to pull themselves back out if there's any sort of evidence that points to maybe what was going on in the past or maybe what some of the allegations were to not be so accurate. We haven't really seen a lot of things being pulled back on any of this. A lot of things just kind of keep coming in going, well, that's damning. That's damning. Of course, his area of study, there's many other people who are in that exact same area of study But when it comes to all of the other pieces of evidence, that's where it looks to be very, very dark. If you were to be the defense attorney for someone like this, how do you begin to handle your client when there does appear to be so many real damning pieces here that don't look like they're going to play out so well in court any way you fold them?
If I was representing Kohberger, I would immediately start preparing for a mental health defense. I would have him interviewed by competent doctors who have experience in testifying in a not guilty by reason of insanity trial. It is very, very specific law. And, it's kind of wild the way it's written, because if you are going to pursue a defense of not guilty by reason of insanity, you have to have been at the time of the crime operating under a delusion that, if it were true, is either morally correct or legally correct. So it has to be developed. There has to be evidence of it beforehand. So, for example, there's two different scenarios that I've actually had in cases before. One is somebody is hearing voices saying that their father is actually a three-headed dragon that is out to kill the population of children in their community. And this person sees their father, and all of a sudden the father looks like a three-headed dragon. His head turns into a three-headed monster. And at that point, the client says, "It is my duty to kill this monster so that it does not kill the children." There's documented evidence of these delusions happening before the incident. There is documentation that he had mental health issues previous to it that related to delusions. And it was a valid mental health defense. And it's up to the jury at that point to decide whether or not they believe it. But that's something that can be presented. In another situation, a client said, "The devil was telling me I have to kill my wife, so I stabbed her." That does not give you a valid mental health defense, because the devil telling you to kill your wife is not morally correct and it's not legally correct. So it's crazy that inside of this delusion, you have to have some kind of rational, you have to break down the delusion rationally inside of your head and say, well, if the devil is telling me to do this, should I do it? So it's wild, and it's very, very intricate, and there are a lot of moving parts. So what I would do to defend him at this point is first see if there is a valid mental health defense, because that way you get away. You could potentially, if you can present enough evidence to the prosecution, avoid a jury trial completely. If the prosecution will agree, then you can. I seriously doubt in a murder like this, a prosecution would just agree to let him plead not guilty by reason of insanity, but it's your duty as a lawyer to explore that as quickly and as thoroughly as possible.
And that's what is very interesting about this case, because there likely is some sort of mental health issues going on here with him, probably some sort of personality disorder or disturbance. My guess is it's not going to be a three-headed dragon or believing the devil was telling him to do these sort of things. It seems more likely something of some sort of angst against women and things of that nature, which would be, I don't know if that qualifies as a delusion. I would assume probably not, more so something along the lines of a hatred or a preconceived notion of under other individuals. How would something of that nature play in a case like this if he has some sort of belief that women are rejecting him, that they're bad, that they're evil, or whatever, what have you, and that it's his duty to go out and correct this in whatever way he thought possible? Obviously a heinous way if that's the way he was doing it, but would that be a delusion?
Well, it could be a delusion, but again, remember, if you're operating under delusion, it has to be a delusion that's either morally allowable or legally allowable. So if you are not an experienced defense attorney in the mental health defenses, you run a very, very huge risk to your client, because in developing that kind of a theory, if a defense attorney was to say, I have, he's been interviewed and here is you don't have to turn it over. If you're a defense attorney and you these are all they're confidential experts. So a defense attorney never, ever, ever has a duty to turn over something that will hurt their client. You're not allowed to do that. So you have to be very careful, because if I were to develop a theory of defense that he was operating under a delusion that women are bad and he's been anointed to, take down these two women, that could be used by the prosecution as a motive. It is not a mental health defense. And if it's determined by a jury that he was competent at the time of the event, meaning he understood what was happening, and he's also competent at the time of trial, meaning he's understanding the legal proceedings, and also he is able to help his defense. He's able to help with his defense, if those things are found, then all you're handing over to the prosecution is a motive as to why he killed these people, not a defense. So it's a very fine line sometimes. If there's a doctor that can craft that defense in a way that he can make it sound like it is morally acceptable or legal, then okay, fine, but that's a fine line there.
Yeah, I mean, I have no idea how you would twist something into that way.
I don't think that would fly.
No, not at all. Let me ask you about that, but as far as being mentally competent at the time of the actual crime and then at the time of trial, does the individual, the person here that we're accusing, have to be not mentally competent in both places? Or could they have been not mentally competent at the time of the crime and then now today able to look at this and say, yeah, this is horrible, I shouldn't have done that, but I was not competent then, but I am now?
So the law does not allow for people who are currently mentally incompetent to stand trial. You have to understand the nature of the proceedings against you, and you also have to be able to assist in your defense. So no matter what the crime is, if you are not competent to stand before that jury, your proceedings will be suspended. And every court has a mental health facility that people in those situations are sent to. So your proceedings are suspended indefinitely. You have to have a check-in every once in a while, where someone at the facility says, yes, he's still incompetent. We've determined that he's not able to comprehend, so we want another continuance. In anything where the maximum confinement is not life. So let's say it's a robbery and let's just pick 6 years as the maximum.
Sure.
In any case where it's not life, you can only be held without your trial for the maximum of the punishment. So if you got the maximum, if you were convicted and got the maximum and it was 6 years, you can only be held in that mental facility for 6 years. And then even if you're still incompetent, they've got to unlock the door and let you out. Now there's other procedures at that point where either family members or the state themselves can come in as a conservator and say, I think this person is a danger to society, but that's a whole completely different issue. That's a civil commitment. But they can use that 6 years of treatment against that person to keep them locked away if they think they're still dangerous. In a murder, since life, or potentially if it's a double homicide and there are special circumstances, potentially death, there's no end for the suspension of criminal proceedings. If you are just incompetent for the rest of your life, then you can be held for the rest of your life, because you can only be held for the maximum of the crime that you're accused of.
This is an examination of the hidden human condition.
This is the Hidden Killers Podcast
With Tony Bruschi.
Leading criminal defense attorney, Alexandra Kazarian, thank you so much for joining us. We have more conversation with her in just a few moments, so be sure to press subscribe wherever you download podcasts so you don't miss that part of the conversation as well. We're going to get into the gag order and much more. My name is Tony Bruschi. Stay with us.